Article 2, Employer Rights, Union Rights. Definition of employer. Section 2.01. Certain qualifications, knowledge, experience, and proof of financial responsibility are requested of anyone desiring to be an employer in the electrical industry. Therefore, an employer who contracts for electrical work is a person, firm, or corporation having qualifications and maintaining a place of business for the purpose of storing materials, trucks, and equipment, and a place for the safekeeping of workers' tools when not in use on the job. He shall further identify such a place of business with an appropriate sign stating the nature of the business. He shall maintain suitable financial status to meet payroll requirements. Such employer must be in possession of a valid state license as an electrical contractor and employing at least one journeyman wireman regularly. A shack or office at the job site shall not be recognized as permanent headquarters. Management Rights, Section 2.02. A. The union understands the employer is responsible to perform the work required by the owner. The employer shall therefore have no restrictions except those specifically provided for in the collective bargaining agreement, in planning, directing, and controlling the operation of all his work, in deciding the number and kind of employees to properly perform the work, in hiring and laying off employees, in transferring employees from job to job within the local union's geographical jurisdiction, in determining the need and number as well as the person who will act as foreman, in requiring all employees to observe the employer's and or owner's rules and regulations not consistent with this agreement, in requiring all employees to observe all safety regulations, and in discharging employees from proper causes. B. The employer shall have the right to determine the competency and qualifications of its employees. The union may institute a grievance procedure under the terms of this agreement if it feels any employee has been unjustly discharged. C. In applying the above provisions, the employer shall not discriminate against employees in regard to hire or tenure of employment by reason of union membership, provided, however, all workers, union or otherwise, shall be classified and receive a wage scale as provided under the wage schedules incorporated in this collective bargaining agreement. D. Any individual employer who violates any of the sections of this agreement may be cited before the Labor Management Committee. In the event an adverse decision to the employer is rendered by the Labor Management Committee, they shall immediately notify the union of the action. Foreman Callouts, Section 2.03. The employer shall have the right to call a foreman by name, provided A. Individuals are eligible in the highest priority group, B. Individuals meet standards stipulated by the parties to this agreement. Workers' Compensation Insurance, Section 2.04. Registered Electrical Contractor. No employee shall work for an employer unless such employer provides the union with a certificate of workers' compensation insurance through a reputable company, complies with Federal Social Security Act, California Unemployment Insurance Act, and is a registered electrical contractor in the state of California, and possesses a business license in the county of San Mateo where the work is being performed. Surety Bond, Section 2.05. A. Payroll and Fringe Benefits Guarantee Deposit. Each employer not previously qualified or a member of the NECA West Bond Fund shall maintain on deposit with the administrator of the various fringe benefit programs an assignment of cash on deposit, and a performance bond as follows. Each employer with less than 5 employees, $5,000 cash on deposit or $2,500 cash on deposit, and a performance bond in the amount of $2,500. Each employer with less than 10 employees, $20,000 cash on deposit or $5,000 cash on deposit, and a performance bond in the amount of $15,000. Each employer with 10 or more employees, $30,000 cash on deposit or $10,000 cash on deposit, and a performance bond in the amount of $20,000. Each employer with 20 or more employees, $50,000 cash on deposit or $20,000 cash on deposit, and a performance bond in the amount of $30,000. Each employer with 40 or more employees, $100,000 cash on deposit or $35,000 cash on deposit, and a performance bond in the amount of $65,000. B. This will be surety of the prompt and full payment of fringe benefit contributions. Individual employers who fail to remit as provided herein shall, upon 72-hour notice, except Sundays and holidays, by registered mail given by the union, be subject of having the employees removed until such time as compliance is effected. Bond forms and assignment of cash on deposit forms shall be in language written and subject to such procedures and regulations agreed to by the parties to this agreement. C. Any employer may be subject to an audit in order to determine whether the employer is making full and prompt payment of all sums required to be paid under this agreement. If there are monies due, the employer will pay the cost of the audit unless the parties waive such cost of the examination if the discrepancy is minor and not willful. D. On the first default of payroll payments and/or fringe benefit payments, the defaulting employer shall, upon notice from the administrator, furnish additional cash or cash equivalent bond in the amount of $10,000, as guaranteed that wage payments and fringe benefit payments will be regularly made. Failure to furnish the above referred to cash bond shall constitute cause for immediate cancellation of the collective bargaining agreement at the option of the local union and the processing of all legal procedures necessary to enforce collection of defaulted amount, plus collection costs and interest involved. It shall not be a violation of this agreement for the union to refuse to permit persons covered by this agreement to work on said job or projects until all such wages and or fringe benefits have been paid. E. Whenever an employer has definite knowledge that he is taking over a contract for a job that has been partially completed by another contractor, he shall notify the local union in writing in the area before starting work. On any job or project which has been partially completed by an employer and work therein has stopped because of the failure of the contractor to meet his current obligations, and money is due and payable to employees and wages and has not been paid, and or money is due and payable to existing fringe benefit funds and has not been paid, it shall not be a violation of this agreement for the union to refuse to permit persons covered by this agreement to work on said job or project until all such wages and fringe benefits have been paid. F. Net payroll checks shall be paid by the payroll and fringe benefits guaranteed deposit account in the total amount not to exceed $3,500, maximum per employee. G. The payroll and fringe benefits guarantee deposit account shall not advance for the benefit of any one employer an amount in excess of the deposit with the administrator of the various fringe benefit programs. Non-resident employees, Section 2.06. An employer signatory to a collective bargaining agreement or to a letter of assent to an agreement with another IBEW local union who signs an assent to this agreement may bring up to 4 bargaining unit employees employed in that local union's jurisdiction into the local jurisdictions and up to 2 bargaining unit employees per job from that local jurisdiction to this local jurisdictions for specialty or service and maintenance work. All charges of violations of this section shall be considered as a dispute and shall be processed in accordance with the provisions of this agreement for the handling of grievances, with the exception of any decision of a local labor management committee that may be contrary to the intent of the parties to the national agreement on employee portability upon recommendation of either or both the appropriate IBEW International Vice President or NECA Regional Executive Director, is subject to review, modification, or rescission by the Council on Industrial Relations. Favored Nations, Section 2.07. The Union agrees that if during the life of this agreement it grants to any other employer in the electrical contracting industry on work covered by this agreement any better terms or conditions than those set forth in this agreement, such better terms or conditions shall be made available to the employer under this agreement, and the union shall immediately notify the employer of any such concession.